only so far as they are concerned, you can directly approach the High Court.
Okay.
But so far as private parties are concerned, you can't approach the High Court directly. You have to go to the trial court.
Okay.
So, for example, in Bangalore, it will be the civil court that you will have to approach. It deals with RERA.
Okay.
It deals with the Karnataka Apartment Ownership Act. It deals with the Karnataka Cooperative Societies Act, as well as Karnataka Society Registration Act. The court said, look, KOA, which is the 1972 Act, is only for owners and it's not for allottees. So what the RERA did, which is very interesting, I thought.
Hi Sneha, good morning.
Hi, good morning.
The last conversation that we had was very interesting. We had a lot of interest on YouTube and other channels. And recently we were discussing about a judgment that was passed by Honorable Mr. Justice Suraj Govindaraj. You said it was a very interesting judgment and we thought we'd have a conversation about that. Do you want us to understand on a high level what it is and then we'll dig deep? Give us a basic understanding of the conversation they had and what was passed, and then we'll dig deeper into it.
Sure. So the crux of the issue was regarding society under the Karnataka Cooperative Societies Act.
Okay. So this was something that people have not been talking about. Earlier there was a lot of conversation on the Karnataka Apartment Ownership Act.
Correct.
So this is something similar but different.
Yes. So the good thing about this judgment is it deals with RERA.
Okay.
It deals with the Karnataka Apartment Ownership Act. It deals with the Karnataka Cooperative Societies Act, as well as Karnataka Society Registration Act.
So all the
legislations.
four, even KOFA.
And KOFA.
Yeah.
Yes.
Okay.
So all the legislations have been dealt with. So I feel in terms of clarity to a lot of apartment associations or owners of flats, it's a fantastic judgment in that sense. It's analyzed really well, briefly done, but also there are all the relevant details.
Okay.
What
is the crux? Let's start with what the problem was, and then let's go into it.
Yeah. So the facts were, this is actually a very typical case where some bits of the apartment were constructed, some were not. So this is, I think, around 5.5 acres of land where there were 5 towers, A to E. B, C and D were completed.
Okay.
A and E, the 2 towers, were not completed.
Okay.
So what happened is, the 3 towers which were completed, they formed an association under the Karnataka Society Registration Act, 1960.
Okay.
Now the 2 incomplete towers also formed a separate association under the Karnataka Society Registration Act.
Okay. Same thing.
Yes.
Okay.
So the 3 towers which were completed formed this association and started collecting maintenance.
Correct.
The 2 incomplete towers formed an association under the Karnataka Society Registration Act, and they went before RERA. They filed a complaint before RERA.
Okay.
Saying that please direct the promoter or the developer to complete the towers and the project.
Okay.
So what the RERA did, which is very interesting, I thought, they directed the promoter to complete the project. They also said that you need to go register or form a society under the Karnataka Cooperative Societies Act.
Are you saying that RERA has told all the 5 towers or only
No,
these 2
only
towers?
the incomplete towers. There was a general direction saying that allottees, please go and register yourself under the Karnataka Society Registration Act. But I've also not looked at the RERA order. I'm only going by the very limited reading of what is mentioned in the judgment.
No, you use the word allottees.
Allottees.
So it's a new word. Do you want to differentiate between allottees and owners?
Yeah.
Because you use the word allottees and you also mentioned that it is incomplete. So is there a connection between allottees and incomplete?
Yes. So I'm coming to that because this is actually one of the questions that the court answers.
Okay.
But I'll cover the facts and I'll jump into that quickly.
Sure. Okay.
So that direction was given and a society was formed under the Karnataka Cooperative Societies Act.
Correct.
In the meantime, there was, I think, the 2 Society Registration Act, the Allottee Association and the Owner Association came in some kind of conflict. There was also a complaint filed before the Registrar of Society saying cancel the registration
Okay.
so far as the completed towers society is concerned, because under Karnataka Society Registration Act, you cannot collect maintenance.
Okay.
And the Registrar of Societies cancelled that registration as well.
Okay.
So because all these people under various associations and all of that happened, there was too much of conflict and everybody were at loggerheads. So through challenging the RERA order and through challenging the society's, cancellation of the registration certificate is concerned, everybody came to the High Court, saying that please help us decide. The most important question that they all sought for, other than, let's quash this order, give us this kind of a direction, they said, direct all the parties and the promoter to form an association under KOFA.
Okay.
That was a unanimous kind of a prayer sought for by all of them.
So this is both the warring parties
as well as the
and RERA. Okay.
Yeah. I mean not RERA, both the two different,
the
complete
parties.
towers and the incomplete tower owners.
Got it. Yes.
Now the first question, like the question that you asked, is something that the court dwelled into.
Okay.
It said there is a difference between.
Sorry, before we go there, let me just, because this is kind of complex, I will try and paint a picture of the understanding. There is a society that's being built, 5 towers. 3 towers are completed, 2 towers are in progress. Both of them form societies under the Karnataka Society Registration Act 1960. One is complete, one is not complete. Then they approach RERA.
The incomplete
Section of the project approach RERA. RERA suggests or directs them to form a society under the Karnataka Cooperative Societies Act.
Yes.
And then they all approach the court.
Yes. So the faction of incomplete towers also files an application.
Okay.
Before the registrar of society seeking for cancellation.
And that gets cancelled also. That gets cancelled. Then they approach the court.
They all come together.
And
saying
that they ask them to form it under the KOA.
Of course, there were other issues as well.
Yeah, but this is what we're talking about in this.
Yes.
Perfect. Now let's go back to what we were discussing, allottees versus owners.
Yes. So what the court said is, look, if you are, so the primary difference between an allottee and an owner is an allottee is a person to whom a flat is allotted but not yet sold.
Okay.
Because either your project is incomplete or you don't have an OC. Therefore, the sale deed is not made in your name, but an agreement to sell is there.
Okay.
But an owner is somebody who has the sale deed.
Okay. So the rights between an allottee and an owner slightly varies.
Slightly varies in terms of law, and their rights are also very different.
Okay.
So the court said, if you're an allottee, you can go before RERA.
Okay.
However, you need a sale deed if you're an owner. That's the distinction between the two. Now coming to the question of the allottees coming together to form an association under KOA or Karnataka Cooperative Societies Act. The court said, look, KOA, which is the 1972 Act, is only for owners and it's not for allottees. If you are an allottee, as mentioned under RERA, you can form a society under the Karnataka Cooperative Societies Act.
Correct.
However, as an allottee, you cannot form an association under the Karnataka Apartment Ownership Act.
Okay.
So that point was very, very clear. The court also looked at other questions.
Sorry, this brings the question that this is a project that is under construction, right? So what happens after an allottee becomes a owner?
So I will actually answer that question towards the end.
Okay.
Because in fact in this judgment, the court goes into how when you form an association under the Karnataka Cooperative Societies Act, thereafter you can continue that society and collect maintenance, subsequently becoming an owner as well.
Karnataka Cooperative Societies Act can actually collect maintenance.
Yes, which has anyway been the case in terms of law.
There is a judgment on that.
Today there is a judgment that clarifies, because Karnataka High Court previously had also said Karnataka Cooperative Societies Act is applicable for commercial units only.
Okay.
So this judgment also clarifies that particular aspect.
Got it.
Now the first question was allottee of association can only be formed under Karnataka Cooperative Societies Act, not under KOA. That was clarified.
Okay.
Next is whether there is any conflict between RERA and KOA, which is your 72 Act.
Correct.
And the court said, no, there is no conflict. RERA applies to disputes during construction and also for developers, for developer disputes pre-construction or during or pre-construction or pre-ownership.
Pre-ownership, okay.
Pre-ownership. However, KOA applies post construction once the apartment is sold and when the property is for maintenance.
Okay, so then if I'm a homeowner and I'm taking over, so we are talking about a whole society, but this also means that it has an impact of a homeowner, because a homeowner cannot go before RERA if he's already signed a sale deed.
No, that's not what I mean. We're
Okay.
talking about associations. Now,
Okay.
associations are also bodies that can approach the court of law.
Correct.
Right? So there is a slight distinction here. I'm now particularly referring to association or society formed under Karnataka Cooperative Societies Act and association formed under KAOA. Now, association formed under KAOA happens once you become an owner.
Correct.
Therefore, the association cannot go and file a complaint before RERA.
Okay, so association cannot file a complaint against.
An individual home buyer, of course.
Can.
Suppose I have a sale deed and let's say there's been a delay in handing over possession. I can go even though I have a sale deed saying please pay me compensation as far as RERA is concerned.
That needs clarity, because if people, there are two bodies here. One is the KAOA society that is registered and also an individual.
Yes.
Right, okay, got it.
So, the reason that KAOA cannot go before RERA is because pre-construction or during construction, you cannot be an owner or you cannot be a member of KAOA.
Got
Because KAOA, you become a member only once you have ownership.
So, Apartment Ownership Act, so
Yeah.
only after an
After
owner.
ownership.
Okay.
So, during or pre, you can't, I mean, you are not even a body. So, how can you go approach RERA? That's basically,
Okay.
the point here.
What if there's an ad hoc committee?
Correct. So, an ad hoc committee can go.
Okay.
You can be like a voluntary consumer association.
Okay.
That option is there.
Okay.
We're specifically saying KAOA pre-construction or during construction cannot approach RERA because the act only comes into effect when I become an owner and when I submit my apartment
Got it.
to the act.
Got it.
So, which is why the court says, look, if you're an allottee, you can go and register a society under the Karnataka Cooperative Societies Act, which RERA also prescribes.
Correct.
So that clarity has been established.
Okay.
Also, there is no conflict between RERA and KOA.
KOA.
That's also been decided because KOA applies post construction and when you're maintaining the common areas, which is
We'll come to that little
Yeah, we'll
later,
come to
yeah.
that. But in terms of dispute between RERA, it's KOA cannot.
There is also now KOFA.
KOFA.
Yeah.
Right. So the court also looks at conflict between RERA and KOFA. When I say conflict, there are certain provisions that overlaps. Like certain provisions in KOFA overlaps with certain provisions with RERA. Because
you may want to
KOFA
explain what is KOFA.
KOFA is Karnataka Ownership of Flats Act.
Okay.
This came in 1972.
Okay.
And RERA, of course, came in 2016.
Yes.
So KOFA already had some clauses so far as during construction, pre-construction is concerned, which RERA, of course, came in as a legislation bringing a lot of clarity. Because there are some sections which overlap in both these acts, and RERA has a section which says, notwithstanding anything, so it's a non-obstante clause, that's what they call in law, which basically means that notwithstanding any other act, this applies.
What does that mean?
Which means that the provisions of RERA override the provisions of KOFA so far as wherever there is conflict.
Okay.
So if there is, when I say conflict, if the two sections are saying something slightly different, what prevails?
Okay, what? Got
Right?
it.
So then RERA prevails, is what the court said.
Okay.
So there is a bit of conflict, is what the court observed, and it said, look, wherever there is conflict, RERA will prevail, not KOFA.
Okay.
Even if you are registered under Karnataka Cooperative
Cooperative
Societies
Societies
Act,
Act.
because in a previous judgment of Justice Govindaraj, he said that if you are a society registered under the Karnataka Cooperative Societies Act, KOFA will apply.
Okay.
That's a judgment that he had passed. So now he clarifies that so far as there is conflict between RERA and KOFA, RERA will apply.
Okay.
Right?
Yeah.
So the next question that the court looked at is whether the court now has to direct all the parties to form an association under Karnataka Apartment Ownership Act.
Okay.
Now, the first thing the court said is, look, there is a distinction between allottees and owners here. This is not a case where all of them are owners. Some are allottees, some are owners. So he said because they are allottees, they cannot form an association under KOA.
Correct, because you're not an owner, is it?
You're not an owner. And like we already discussed, KOA requires all owners. And in some situations, the developer as well, where he's not sold some of the flats. They all have to come together. 100% is required to form an association under KOA. So that's one of the reasons why they didn't dwell too much into directing them to form an association under KOA. Of course, the court also said, maybe this is a technical point, the court also said that in a writ jurisdiction, I will not direct private parties to form any such association.
You may want to explain what a writ jurisdiction is. I know it's very technical, but it's interesting to understand.
So, writ jurisdiction would mean when can you approach the High Court by filing a writ petition?
Okay.
Only when the other party is state. Okay. When I say state, I mean any statutory authority, state government.
Any government representative body.
Okay. Only so far as they are concerned, you can directly approach the High Court.
Okay.
But so far as private parties are concerned, you can't approach the High Court directly. You have to go to the trial court.
Okay.
So, for example, in Bangalore, it will be the civil court that you will have to approach.
Okay.
So, suppose I want, a lot of owners are not coming forward to form an association under KOA because 100% is required. Then parties that are ready can file a case before the civil court seeking the court to direct all the parties to form an association under KOA.
Got it.
Now that does not classify to be a writ jurisdiction is what the court said. They said you can approach the right court to seek for this kind of direction if you want. But another important thing, because there were two societies like I initially said that were formed under the Karnataka Society Registration Act. This judgment again reconfirmed what the Karnataka High Court Division Bench had previously decided, saying that society registered under the Karnataka Society Registration Act cannot carry out maintenance activity.
Okay.
So today it's very, very clear that if you are a society registered under the Karnataka Society Registration Act 1960, you are illegal. You are an illegal body so far as maintenance is concerned.
Okay.
That was established. But the good part here was regarding the Karnataka Cooperative Societies Act. Because the owners of 3 towers which were complete, they said, why should we form under Cooperative Societies Act? Or there is a direction given by RERA, why should we conform to it? The court said, look, now the allottees can agitate their rights by forming an association under Karnataka Cooperative Societies Act, and a society registered under the Karnataka Cooperative Societies Act can also carry out maintenance activity, including maintaining the common area and amenities.
Which is anywhere there.
Which is anywhere there in RERA, but it was good that, the court actually came forward to mention this explicitly.
Okay.
So which sort of, wherever this confusion today in terms of which is the association, so you have your answer. It's both. You have a choice, KOA as well as 𝘃𝗶𝗄.
I think the question then begs is, what is more cumbersome, what is easier, what more paperwork,
Yeah,
etc.
also it depends. It depends on your situation.
Yes.
I think
Okay.
So that's sort of clarity. But the most interesting part of the judgment, at least for me as a lawyer, because, people are discussing this over and over again, that RERA has a section which says you need to execute a deed of conveyance transferring common areas and amenities.
So there's been a lot of discussion on that. A lot of people are asking a lot of questions because today the general conversation is, you are giving me my apartment, but you're not giving me the other part of the property.
And RERA says you need to execute a conveyance deed so far as common area and amenities are concerned. But where is that being done? Is a question that everybody is asking.
For people who are not familiar, in a short phrase, explain what a conveyance deed is.
Conveyance deed is a transfer deed, like a sale deed, or a gift deed. Any deed where rights of a party is transferred.
Okay.
That's basically a conveyance deed.
Got it.
So because RERA has provisions so far, at least as far as my knowledge is concerned, I'm not aware of any developer or promoter explicitly transferring common area and maintenance through a deed.
Okay.
Because what they essentially do is they're transferring the UDS of the land and 𝗃𝗶𝗱𝗃𝗀𝗃 to various flat owners, saying that I have transferred the entire land and the 𝗃𝗶𝗱𝗃𝗀𝗃 to all the owners. Therefore, I have nothing left to transfer. That's been the situation that everybody is operating as of today. But what's interesting here is because Allottees also approached court, who are not owners. The court actually has directed the promoters to execute a deed of conveyance and transfer the common areas and amenities to this cooperative society.
Oh wow, okay. So the cooperative society.
Yes.
Okay.
Because that's what RERA recognizes. And it also says that, look, under KOA, this is not possible. And that's why the court also says, go seek for a legislative clarification, before the Law Commission.
So to paint the picture now, you have both valid acts, KOA and Karnataka Cooperative Societies Act, where you can collect maintenance and run your society. However, the conveyance deed can only be passed on to the Karnataka Cooperative Societies Act, and there needs to be clarity on the KOA segment right now.
So, clarity in this whole segment, I would say.
Okay.
The reason being, now, why you can't transfer a conveyance deed to an association under KOA is like I already explained.
Yes.
The 𝗃𝗶𝗱𝗃𝗀𝗃 is already given.
Yes.
The UDS is given. So what's left?
Yes.
Therefore, there's no need for an explicit conveyance deed of common areas. Because that's how Karnataka Apartment Ownership Act is construed.
Okay.
It says that, look, once
So there
you
just needs to be
submit...
clarity. Somebody needs to clarify that yes, it actually is equal to this.
No, that's not what it means. So, that's not how the court has said. It basically means that, look, it says that under KOA, the reason you can't transfer is because you're submitting the entire scheduled property, which is your entire land, to KOA. And the minute you submit that, automatically the association has a right to maintain common areas.
Okay.
Nowhere does KOA says the association is the owner. It says association is a custodian.
Okay. That makes a big
Owners, I mean, the flat owners are anyway the owners of all the common areas and amenities.
So it differentiates between the association and the individual homeowner.
Yes.
Okay.
Association is only a custodian.
of it.
It's not an owner.
Okay.
But RERA, the way the act has been framed, it says you need to execute a conveyance deed to the society or the association, which essentially means it's saying that the association becomes the owner so far as common area is concerned. So therefore, under KOA, it's not possible for you to do this kind of a conveyance deed.
Okay. If that happens, then you have more questions as to how, if somebody is not using a service, then how do you collect payment expenses? That's a different conversation altogether. Got it. Okay.
But so far as cooperative society is concerned, the way RERA is, describing things to happen, it appears that as an allottee, you can form an association under the Cooperative Societies Act. And when the sale happens, the promoter actually has to execute a conveyance deed transferring all the common areas and amenities to the registered society.
Got it.
So it's going to be very interesting to see how this order is going to be implemented by the promoter, because this is one of the very first cases that at least I'm aware of where such a direction has been given by the court to a promoter who now has to execute it within 120 days is the timeline given.
Okay.
But it'll be interesting to see where this goes.
Nice. So there was a reference to a catch-22 in the whole conversation.
The catch-22 was on this.
Sorry?
It was on this.
Yes. Yeah. Oh, so what was? Why did you say it was a catch-22?
Because how do you now implement this provision of RERA? Saying it's a catch-22 because 3 towers have been sold.
Okay.
So I'm sure he's already sold some bit of 𝗃𝗶𝗱𝗃𝗀𝗃 and UDS to the 3 towers.
Okay.
Now 2 towers have not been sold.
Okay.
And then there is a society registered under Karnataka Cooperative Societies Act. Now the court is directing him to follow RERA, saying that you transfer a deed of conveyance.
So this is also done, that is also done.
That's
so
also done, so then what do you do?
So he's got to take it back and then
we don't know. We don't know. So we don't know. Okay. And plus, the court has also said there is a bit of legislative clarification that's required. Because there is a conundrum here. That's also something that we need to look at.
That is the right word. There is a conundrum.
There is.
But there is a lot more clarity
yes.
than there was before. Yeah.
Of course, in some areas there is no clarity, but that's okay. I think even though there are some areas which there is no clarity, we are still in a situation where things are workable, where your entities are still legal. There's no threat, whether you're under KOA or KCSA. Only if you're a association under KSR, there is an
Karnataka
issue.
Societies Registration Act.
Otherwise, there's no issue, because it's not that your common areas, nobody knows who has it. It's not that it's sitting with the developer. It's none of that. It's basically an internal.
It's an A versus B conversation where both of them are legal. It's just that you need
implementation is what we really need to figure out.
And which is better for which situation.
Correct. And also it's good if there is a universal implementation of how common areas have to be dealt with. Do you sell it to owners like the way it is being done now, or do you not give them all of that but then transfer it to the association? Because that's the intention RERA came up with. That's conflicting with the way KOA is right now. So that's some kind of a...
So it's in a more in-depth conversation that needs to be had.
So to that extent, it's a catch-22, because then what do you do?
Okay. There's been a lot of buzz about a potential new law which is going to take care of all the problems. Do you have anything to say about that?
Yeah, I mean, I've also read that a new, something is going to replace KOA and I mean, look, as a lawyer, when I read these newspaper articles, I'm just going to read them as newspaper articles, because so far there is no draft legislation that's been published.
Okay.
I will probably take this very seriously when a draft legislation is published and when they ask us for our comments.
Okay, so draft legislation, you may want to explain to people who are not
Basically,
lawyers.
the Parliament will put the legislation together, the act together, and they will release it to the public saying, please send us your comments. This is a draft that we intend on enacting as law.
Okay.
Now you please send us your comments.
Okay.
Right? That's when I know that they're serious, because even after that there are a lot of things that the legislature has to do in terms of enactment.
Okay.
But when the draft is out, it's more serious that they are going to introduce something, a new law is going to come in place.
Okay.
Well, probably for the good, if something like that does happen, because there are some conflicts, some conundrums like we discussed. But I think it's a wait and watch situation.
Let's wait and watch. It'll be nice to see what comes out and what we can comment on.
Yeah.
Before we conclude, we've had a lot of conversation on allottees and owners. I think we should probably have another conversation next time on RERA and the rights of allottees.
Yeah.
Because today we have a lot of societies that are, as we've talked about, semi-finished, finished, it's not been handed over, there's a delay, etc. So I think our next conversation should be about allottees and their rights.
Yeah.
And we can invite our audience to have any questions that they would need answered, and we can also probably discuss that.
Certainly.
Yeah. Well, thanks again. It was
Thank
nice
you
talking
so
to you.
much. Yeah.
And we'll get back to you guys with more shortly.